Right, next up is George. Hi, George.
Hello.
Hey, George.
How we doing?
What's your question for either Robert or Vic?
My question is, I've had a 30-day notice to vacate the property, but it's not over non-payment. It's over a person that's taken over for a lady that's got dementia, and she wants us out, and she gave me a 30-day vocal to get out. So I want to know what's the next step.
Robert?
George, did you say she gave you a 30-day vocal, meaning just a verbal notice to vacate the property?
That's right. It's not because we're not paying. It's because she don't want us here anymore.
Yes, sir. Well, whether or not she can enforce that, the landlord's going to depend on whether or not the contract or the lease is in writing, covering whether or not you can sublet. But just the same, whether or not she can kick you out verbally, that also needs to be put in writing to even have any effect. So first step you need to do is get your lease if you have one. Second step you need to do is document all of your correspondence with this landlord. And then third, but most importantly, you need to get involved with a landlord-tenant specialist to fight for your rights as far as this home that you're in.
And I'll tell you, the magistrate judges really do a good job of helping tenants in that kind of situation, George. And so you should move immediately to protect your rights and get a lawyer to help you out to get the proper filings done.
And with COVID and the protections for tenants, haven't things kind of stretched out a little bit? Like if someone says, you need to leave, the realistic time, isn't it months before someone actually has to leave?
Well, there was a long period of time where you couldn't evict people.
That's true.
But
yeah.
that's now over. So the law is being applied now. And if George didn't have a written lease, then generally you get 60 days, don't you?
Yeah, at
Robert?
that point, without a lease, I believe it would become a month-to-month or a tenant at sufferance.
Right.
And she's going to have to do a little bit more than just tell you verbally you need to vacate. So stand up for yourself. You may even be able to recoup your attorney's fees, make her pay you back for those, and win.
Yeah. Yeah, we like winning.
We like winning.
And they like getting attorney fees.
That's
too.
right. We like that.
Yeah.
You know, before we came on the show, Robert and I were talking about something that we thought might interest you. And one of these is these pre-warrant applications that are being made in Columbia, Richmond, and Burke County. Can you explain to our public a little bit about that?
Of course, Vic. So imagine this. You have a dispute with somebody, whether it's your spouse, your girlfriend, boyfriend, your neighbor, whoever it is. You call the police come there. They can't really determine who's at fault because they've got 2, 3, 4 people telling 5 to 10 different stories. So they say, well, we can't do anything, but if you'd like relief, go down to the magistrate court and swear out a warrant application. That means you go to magistrate court, you do an affidavit with what you're accusing the other person of doing, and then they are summoned to court for a probable cause hearing. And if you receive one of these summons where you're being accused of something and there's a warrant application in magistrate court, you need to hire a lawyer ASAP, no matter how incorrect you think the accusation is. When you go to that hearing, you're either walking out and it's done, or you're not walking out and you're going in a side door to lockup to be transported to the county jail. So call a criminal defense specialist if you're summoned with a magistrate court warrant application.
Excellent.